पढ़िए हमसे पूछ के थोड़ी पढ़ना है।
ये riots are not rejected by the landlord from the holding on the ground that he has used the land in a manner not authorized by section 14 except in execution of an order.
ये वाला सेक्शन 14 कहाँ लगता है इसमें? इसमें तो ऑक्शन में हुआ।
तो ऑक्शन वो कंफर्म नहीं हुआ था, जो मेरा ये समझ।
ऑक्शन अलग चीज है। डिफॉल्ट पर ऑक्शन इज डिफरेंट फ्रॉम नॉन यूज ऑफ द लैंड।
हमारा एक लाइन सर, इस शेष जमीन बचा था।
किस प्रोविजन में ऑक्शन हुआ था ये बताइए। वो आपको नहीं मालूम। अच्छी बात।
ये जमीन जो तबाद आदिवासी किए थे, इनको तो उस जमीन से कोई लेना देना है नहीं।
May I submit something?
Yes.
In this entire from the order no documents either before the commissioner or before the settlement officer or before this honorable court the private respondent has produced showing their settlement or confirmation of their settlement by any competent court. The land has been settled by to the petitioner by the sub-divisional officer in eviction case on payment of the arrear amount, and it has been finally delivered to the petitioner, and the petitioner was continuously paying the rent, and the private respondents who were the laborers working on at the instance of the petitioners, now they are claiming the title and in Santhalpura the land is not transferable, it cannot be transferred in such a manner. Since he had
under which provision the auction has been held?
It is Santhal civil rule, there is a rent eviction suit is being initiated, Santhal civil rules.
Rent eviction suit?
Yes, rent eviction suit.
Yes.
1872
Santhal civil rules.
Santhalpura settlement regulation 1872.
Just a minute.
Section 27 was there, but the section transfer of rentals that has been repealed in 1949 Act, and thereafter section 27 a limitation for rent suit is there.
I have 1949 Act. I have 1949 Act.
No, 1872 regulation is there, part of that book is there. 1949 is a supplementary act. In that act, this is a kindly peruse section. The section 72.
1872.
First of all, 1949 Act, section 72, the last section.
1949.
Yes,
Last
last section.
section.
Yes, because it is a supplementary act.
Yes, I've got this.
Section 72, saving of special enactment, nothing in this act shall affect any other law.
That's right. 1872 कौन सा section बोल?
Yes, that उसमें rent section 27 was transfer of rights जो होता था.
That's
उसके next 27A में limitation for rent suit जो होता था.
That's right.
Yes.
आप 1870
1872.
हाँ ये वाला आप कौन सा section रेफर कर रहे हैं?
1872 का section 27 and 27A I was.
27 transfer of royalty rights.
Yes, that has been repealed by the 1949 Act. At that time, because that it is before 1949.
This option is before
1949, definitely. And the limitation is there 27. And there is a provision in the Santhal Civil Code which is also applicable not as per section 72 of the 1949. In that there is a clear cut the provisions for rent. Santhal rent and Santhal Puna rent regulation 1886.
Yes, take. What do you have to say? Page. Yes.
The settlement made with the father of the commissioner was set up by sub-regional of the paper was not approved by competent authority. And the petitioner was not found position over the land in question. Adivasi Rayat have been actually found in position over the land in question. Hence the settlement is a paper and that was the order for opening of father, current survey and settlement operation in the name of Adivasi Rayat who are in actual position over the land in question. It was also found that Muhammad Saraf was not in the year of the murder, but was outside from Devghat and settlement was made without issuance of notice to 16 Anna a year and without the approval of the union.
Under what provision of law there is a difference between just a cancellation of work settlement and Normally, the property is declared forth and then it is settled. That is the procedure, isn't it? Where is the provision that in an auction, the matter has to go back to the deputy commissioner or to the commissioner for the purposes of confirmation? Where is such provision? सर्च एलपीए में सर्च करेंगे. कहाँ से सर्च करके बताइएगा. The sale certificate was issued.
Yes, yes.
Where is the sale certificate?
Not that I mentioned, that's why I said final delivery of position.
Sale certificate.
Sale certificate is not issued. The delivery of position was given, and the below annexure 1, the first page, Lord, it was initiated at the instance of the deputy commissioner. Countersigned by the deputy commissioner, Lord. By the order of the deputy commissioner, it was initiated, and this is initiated by the state, not by the petitioner or any private persons, against the Pradhan, who had failed to deposit the rent.
You just come to the civil rules, page 134. A sale certificate is to be given to the purchaser after confirmation of sale. Where is your sale certificate? रूल में लिखा, हम नहीं पढ़ा. 55. A sale certificate is to be issued. Where is your sale certificate?
Lord, as there is no such separate sales certificate and issued as per our, it was as per the order.
Because after the confirmation and after the auction also, there is a provision for filing objection, etc.
Yes, that objection was considered.
Where?
The entire order sheet I have annexed, but the entire order sheet is annexed as annexure 3. The entire order sheet, where notices were issued to the all, even the Pradhan was given.
After auction.
Yes.
Which is that order sheet?
Auction is of
Post auction, what is the date of auction?
exactly. Page 42. Entire order sheet of the proceeding started. Proceeding started on 13/7/1943.
Okay.
Page 36. The proceeding initiated. All the villagers and the Pradhan everywhere given the opportunity. Entire order sheet I have annexed. And thereafter the order was passed as page 42. Pradhan was given the opportunity to deposit the amount.
Where is that?
Page 43, 42, heard the Pradhan and the lawyer and the agent. Two Jamabandi Raya are present. There are others also in the village. The SR notice of Jamabandi Raya is not on record in the circumstances. It is reasonable to issue fresh notice to them. Issue fresh notice, that is that thereafter has been wrongly fixed so and so. Landlord plus village Raya so and so present today on 28/9. Thereafter, below was 17/9/48. Parties plus some village Rayas are present. No Jamabandi Rayas of the Muja is coming forward to take settlement. Babu Hanuman Prasad Saraf, who is Basodi Rayas of the Muja, are applied to pay, agreed to pay the pay of the dues of the plot number 50 is settled with the so and so. No objection to that effect has been filed with the on such and such date PW.
That's all.
Yes, please.
Notice received by paying.
Go back. Thank you. Heard the learned counsel appearing on behalf of the parties. District petition has been filed challenging the order dated 13/1/2004 passed by Division Commissioner Santhal Pargana Dumka in RMR case number 70 of 2002-3, whereby the settlement revision has been dismissed and the order dated 12/11/2001 passed in TL case number 7 of 2001 by the settlement officer Devkar has been upheld. A further prayer has been made to challenge the order passed in TL case number 7 of 2001, whereby the settlement officer directed to record the name of the private respondents as Rayyats, deleting the name of the petitioners in new survey record of right. By giving the foundational background of the case, the learned counsel for the petitioner has submitted that the petitioners are the Rayyats with respect to last settlement clause number 50 pertaining to Jamabandi number 10 of Mauja Charki Pahari number 587 PS Mohanpur subdivision and district of Devghar, corresponding to settlement plot number 118, 119, 120, 121, 122, 123, 124, 125, 126, 127, 128, 129, 130, 131, 132. पूरा ही है 118 to 136.
Yes, now नया plot जो बना
of the same house.
नया plot.
The case of the petitioner is that Jamabandi number 1 was recorded that Jamabandi number 1 of Charki Pahari number of Mauza Charki Pahari number 587 was recorded in the name of Robertson Mehto, who was the Pradhan along with other co-sharers, and it was recorded as Pradhan Ka Jot. The recorded tenant had defaulted in payment of rent and consequently a proceeding for initiation of a proceeding was initiated for his dismissal and ejectment from the post and was registered as RD case number 58 of 1942-43 in the court of subdivisional officer Devghar, and by order dated 17/9/1948, the said Pradhan was dismissed and was evicted from his Jamabandi number 10, including plot number 50 of the said Jamabandi. पूरा ही से evict कर दिया
नहीं, हाँ, पहले उनको evict dismiss कर दिया, बाद में उसको ही किया, change करके उनको ही किया, या आप जमा करके उनको आप restore कर दिया.
The learned counsel submits that in the execution case, being rent eviction case number 58 of 42-43, rent execution case number 813 of 1994 was initiated upon an application filed by the deputy collector cum subdivisional officer, and the deputy commissioner endorsed the application for application again by his order dated 16/2/44 to evict and dismiss the Pradhan. The said application by the Deputy Commissioner has been annexed as Annexure 1 to the writ petition. In the said execution case, notices were issued and the Learned Counsel submits that all the process was followed and the father of the petitioners was ready to deposit the bequeathal dues of plot number 50 and take settlement of the same. And he filed a petition dated 3/11/1947 before the subdivisional officer Devghar and that he was the Basori Rayyat of the village Chakli Pahari and had also obtained settlement of some Pahari land in the village. The petitioner was ready to take settlement of plot number 50 and rest of the jot may be restored to the evicted Pradhan. And the application was also endorsed by the Pradhan. The application is annexed as Annexure 2. The Learned Counsel has submitted that by order dated 17/9/48, the subdivision officer Devghar settled the plot number 50 to the petitioner's father on payment of full bequeathal dues. However, the settlement was made provisionally in view of any objection that may be raised from any quarter. The proceeding sheet, including the order dated 17/9/48, have also been enclosed along with the writ petition. The Learned Counsel for the petitioner has submitted that prior to passing the order dated 17/9/1948, the Pradhan and the Jamabandi Rayyats were also given opportunity of hearing, and ultimately the order dated 7/9/48 was passed. Yes.
In the same page, the decretal amount was also received by the court, the same day, page 43.
And on the same date, the decretal amount was also received by the court. उसी में 23/7/48
Yes, the page 43,
हाँ
received so decretal amount, page 43.
page 40
Right
yes
side.
yes the Learned Counsel has submitted that ultimately the auction was the property was put through the process of handing over the physical possession, and the physical possession of the property was handed over to the father of the petitioner on 27/4/1949 by the subdivisional officer. within bracket annexure 4. And thereafter, the petitioner paid rent to the state continuously and paid rent continuously to the landlord
Yes.
and obtained rent receipts. And the petitioner asserts that the petitioner and their father were in continuous possession of the property. However, when the cause of action arose when the new survey and settlement operation started and the petitioner had put certain persons on the property for cultivation and they were respondent number 4 to 14. And the survey authorities prepared new percha in the name. The survey authorities ultimately prepared new percha in the name of the petitioner's father. The last sentence में लिखेगा. The petitioner raised objection against the wrong The petitioner filed objection in connection with the wrong entry made in the new survey, which was numbered as TL case number 7 of 2001. And the order was ultimately passed in favor of the petitioners on 12/11/2001. ये आपके फेवर में हुआ था
नहीं।
वो भी अगेंस्ट हुआ
वो कर दिए कि इन लोग के नाम पर चढ़ाया जाए
12/11/2001 में TL case number.
टीएल केस में।
However, the claim of the petitioners was rejected and there was a direction to prepare the percha in the name of the respondent number 4 to 14 by order dated 12/11/2001. This order was challenged before the appellate authority, that is the divisional commissioner, the divisional authority, that is the divisional commissioner, which was numbered as RMR case number 17 of 2002-3. And the learned commissioner dismissed the same. The learned counsel for the petitioner has submitted that the orders are of the initial order passed in TL case number 7 of 2001 and the revisional order passed in RMR case number 17 of 2002-3 are contained in annexures 7 and 8 of the writ petition respectively. He submits that at no point of time any procedure was followed for the cancellation of he has submitted that the proceeding by which the property was acquired by the father of the petitioners and they obtained possession stood concluded and attained finality, remained, and at no point of time with respect to the same property, the Pradhan was restored of its rights. He has submitted that the Pradhan was restored of his rights only in connection with the remaining property. And therefore, there was no question of any settlement with respect to the same property in the favor of the private respondents. He has submitted that the settlement under the Santhal Pargana Tenancy Act is preceded by a due process, and merely because somebody was found on the spot, no parcha can be issued in their favor. The Learned Council has submitted that though the courts have recorded, though the authorities have recorded that the Jodh was restored to the Pradhan only with respect to the remaining property, but at the same time, through the impugned orders, the authorities have entered into the legality and validity of the proceedings which had taken place and concluded way back in the year 1948 and attained finality. He submits that such course of action was not permissible. The proceeding by which the property was handed over to the father of the petitioner stood concluded and attained finality, and therefore the impugned orders call for interference. The Learned Council has also submitted that since the proceeding was initiated for realization of the rent and for cancellation, for the cancellation of Pradhan, for termination of Pradhani of the Pradhan on account of default in payment of rent, and the father of the petitioners had acquired the property through the process of court. Which and ultimately were handed over possession. It was not open to the respondents to interfere with such proceeding by stating that final by stating that the settlement was provisional pursuant to the proceedings, and by stating that the Deputy Commissioner had not approved the settlement. The Learned Council for the respondents, on the other hand, have opposed the prayer of the petitioners. The Learned Council for the state has referred to the counter affidavit, paragraph 8, and has submitted that the settlement made with the father of the petitioner by subdivisional officer Devkar was not approved by the competent authority, and the petitioners were not found in possession over the land, and it was Adivasi Rayyats who were actually found in possession over the land in question, and therefore the settlement officer had rightly passed the order for opening khata in the current survey and settlement operation in the name of the Adivasi Rayats. When was a settlement made in favor of the Adivasi Rayats? Any settlement? Date for settlement? वो नहीं. However, upon a query of this court as to when the order of settlement, when the settlement was initially made in favor of Adivasi Rayats, the learned counsel for the state has submitted that this fact is neither apparent from the counter affidavit nor is apparent from the impugned judgment. He has submitted that the entry was made in their favor on the basis of the fact that on the spot they were found in possession. That's right? आपने counter affidavit file किया? The learned counsel for the private respondent has not filed any counter affidavit in the present case. However, he has submitted that. However, he has placed the impugned orders and has submitted that the settlement made by subdivisional officer was provisional, and ultimately there was no approval of the deputy commissioner, and the petitioners and the father of the petitioner was not found in physical possession of the property on the date of survey in the year 1992. In the year 1992, and therefore an order was passed for making entry in favor of the persons who were found on the spot.
हम रेस्पोंडेंट 7, 13 और 14 की तरफ से हैं और हम
किए हैं
बाकी करने
7, 13 और 14 का काउंटर सेटलमेंट ऑर्डर लगाए हैं आपने?
कोई डॉक्यूमेंट नहीं है
7, 13 and 14. The learned counsel has also submitted that a counter affidavit has been filed on behalf of 7, 13 and 14, respondent number 7, 14 and 13, and has submitted that the specific stand of the respondents is that in the year 1948 a provisional settlement of land was made by incompetent authority, and the same was illegal and was never rectified, and was never rectified / recommended. By the deputy commissioner, and as such the claim of the petitioners is illegal and improper. बताइए कहाँ लिखे हैं, कब आपका सेटलमेंट हुआ था और कौन सा प्रोसीडिंग से?
वो नहीं, केवल ये प्रधान के ऑर्डर से हुआ सेटलमेंट हुआ था.
कब सेटलमेंट का पट्टा, कब? कुछ नहीं.
वो नहीं डॉक्यूमेंट नहीं है.
The learned counsel has submitted that the settlement was made in favor of the private respondents by the order of the Pradhan. As the Pradhan ki jot was returned to the Pradhan, and the post of the Pradhan was also restored.
उसमें प्लेन पेपर पर लिख के दे दिया जाता था. वो 43 में उतना कहाँ जुडिशियल प्रधान फॉलो करते.
He also submits that Pradhan was found defaulted in paying rent, and such proceeding was started by the subdivisional officer Devkar in PE case number 58 of 1941, 42-43, and a provisional settlement was made by the order dated 17/9/48. Although the subdivisional officer was not the competent authority, provisional settlement was made in favor of Hanuman Prasad Saraf, the father of the petitioners. He has also submitted that since provisional settlement was made after payment of the due rent / arrears of rent by the Pradhan, the plot number 50 automatically returned to the Pradhan, and therefore the Pradhan had the right to settle the property in favor of the private respondents. यही है आपका केस. After hearing the learned counsel for the parties, it is not in dispute that an application for eviction for arrears of rent, against D. Dev Pradhan was initiated in the court of Subdivisional Officer Devghar in rent execution case number 813 of 1942 under the signature of the Deputy Collector.
Deputy Commissioner.
Deputy Collector लिखा हुआ
नीचे order of the Deputy Commissioner है नीचे last page 34.
and also under the order of the Deputy Commissioner, under the signature of Deputy Collector and also under the order of the Deputy Commissioner. And ultimately, when the father of the petitioner came to know that ultimately in the proceeding, being P case number 58 of 1942-43, the father of the petitioner participated and applied for settlement. And it appears that on 3/11/1947, a joint petition was filed with respect to settlement of plot number 50. So that the arrears of rent be paid by the father of the petitioner in return of settlement of plot number 50, and the remaining jot and pradhani of the pradhan be restored. The proceeding sheet has been annexed along with the writ petition, and it appears that on 23/7/1948, the Pradhan and the landlord's agent and 2 Jamabandi Rayyats were present. And since the service report of the Jamabandi Rayyats was not on record, a fresh notice was directed to be issued. And ultimately, on 17/9/1948, parties and some village rayats were present, and no Jamabandi rayat were coming forward to take settlement. The father of the petitioners, who was a Basori rayat of the Mauza, was ready to pay the dues, and the plot number 50 was settled with no objection. The subdivision officer passed an order that the plot is settled with him provisionally, and the Jot and the rest of the Jot is restored to the evicted Pradhan. It has also been brought on record that ultimately in revision case number 184 of 1948-49, the possession was delivered to the petitioner with respect to the property on 27/4/1949. Thus, the father of the it also appears from the Annexure 5 that the required beating of drum and hoisting of flag in favor of the villagers was also done. A receipt of having received possession was also taken, and ultimately the father of the petitioner was handed over possession. Thereafter, the petitioners was granted rent receipt by the Zamindar, which has also been annexed along with Annexure 6 series, in Annexure 6 series. It was only when the fresh survey started, a TL case number 7 of 2001 was started at the instance of the petitioner, father of the petitioner, as the property was recorded in the name of the private respondents in the survey. The Bandobast subdivision officer के पास settlement officer. The proceeding was initiated before the settlement officer, and the settlement officer directed that the Jamabandi Rayat directed that the private respondents, the name of the private respondents be entered as illegal possession is संबंधित खाता वर्तमान जमाबंदी रैयत के स्थान से बंधित अवैध दखलकार रैयत के नाम से बना है.
Yes, because the original Robertson Motto was the recorded tenant. Now it has been in DL case, transferred this case. Now they have recorded as Aved Dakhalkar as their position also it is declared as Aved Dakhalkar.
Aved Dakhalkar in favor of the private respondents. As Aved Dakhalkar in favor of the private response. The said order was challenged by the petitioners in RMR case number 70 of 2002-3, which has been disposed of by the impugned order dated, which has been dismissed by the impugned order dated 13/1/2004. The perusal of the impugned order reveals that the authority has recorded that in the year 1949, when the father of the petitioner acquired the property, the settlement was provisional, but no approval was taken by the deputy commissioner, and therefore the settlement did not attain finality. The authority also recorded that the property was recorded in the name of the private respondent as they were found in possession over the property. They were in continuous possession over the property, and they had made the property cultivable. The court also recorded that the status of Pradhan and the remaining property was restored to the Pradhan. The authority went into the legality and validity of the proceedings which were conducted by the subdivisional officer way back in the year 1942-43 in case number 58 of 42-43, and observed that the required notices and the required procedure was not followed. And the procedural aspects were not properly recorded by the subdivisional officer in order dated 17/9/1948. And it was not clear as to whether the subdivisional officer had issued notice to the other villagers and the court recorded that, and the authority recorded that on the date in the year 1992, the private respondents were the petitioners were now found in possession, and the private respondents were found in possession, and they are Adivasi Rayyat. And the court also recorded that from perusal of one criminal case in FIR number 39 of 97, it was observed that the father of the petitioners was not the Rayyat of Mauza Charki Pahadi. The authority thereafter ultimately, after recording that the proceeding before the subdivisional officer which culminated in order dated 17/9/1948, was not duly followed, and that the proceeding was and the settlement was only provisional and ultimately dismissed the revision. This court finds that the authority had no jurisdiction to enter into the legality and validity of the proceeding, which had culminated way back on 17/9/1948. It is further not in dispute that the property was acquired by the father of the petitioners in the proceeding initiated for recovery of rent and for eviction of the pradhan before the subdivisional officer through the process of law by the order of the deputy commissioner himself, and it is further not in dispute from the order sheets placed on record that the amount was paid by the father of the petitioner and the property was given in possession after the required process of delivery of beating of drums, etc. This court finds that the possession having been given to the father of the petitioner through the process of court way back in the year 1949 on 27/4/1949. There was no occasion for the respondents to undo any of the action taken in the earlier proceedings. And since the recovery procedure, the suit itself was initiated at the instance of the deputy commissioner for eviction for arrears of rent against the pradhan, and the impugned order also reveals that only the pradhani was restored and the remaining property was restored to the pradhan. There is no occasion to nullify the transactions which have taken place in connection with the property involved in the present case. This court finds that the learned authority have committed serious perversity in entering into the legality and validity of the order of the proceeding, which ultimately culminated in 17/9/1948. And accordingly, the impugned orders are set aside. This petition is hereby allowed.